Members of the Caribbean community, or CARICOM, have participated in several ways in the WTO dispute settlement mechanism. In most cases, CARICOM countries have participated as third parties in disputes initiated by other WTO members in which they had a substantial interest. In a few cases, CARICOM countries have also participated as a complainant in one case, and in a couple of other cases also, they have had to respond to allegations that their measures were not consistent with WTO rules. In one case, that is the case initiated by Antigua and Barbuda, against certain measures taken by the United States with respect to the cross-border supply of gambling and betting services. A member of the Caribbean community used the WTO dispute settlement mechanism as a complainant. The experience of Antigua and Barbuda in that particular dispute has illustrated some of the opportunities and challenges that small developing countries face in utilizing the WTO dispute settlement mechanism. In that particular case, Antigua and Barbuda initiated in 2003 consultations with the United States to challenge its measures affecting the cross-border supply of gambling and betting services. Ultimately, those consultations did not resolve the dispute, and a panel was established to consider the allegations by Antigua and Barbuda that those measures were not consistent with the commitments of the United States under the General Agreement on Trade and Services. The findings of the panel in that dispute ultimately ended up being referred, some of them, to the appellate body of the WTO for review. And ultimately, there were some aspects of federal laws of the United States that governed interstate horse racing, which actually were found to be inconsistent with the United States commitments under the General Agreement on Trade and Services. Unfortunately, the dispute remains unresolved because both sides have actually not found an amicable solution. The United States opted to withdraw or modify its commitments with respect to gambling and betting services, and it has not reached agreement with all affected members on the compensation that should be provided for withdrawal of those concessions. Antigua and Barbuda, in this particular dispute, has maintained that adequate compensation would not take the form of the provision of market access in other areas, and it has actually sought, as a result, authorization from the WTO's dispute settlement body for authorization to use retaliation to secure compliance of the United States with that particular, with the rulings of the dispute settlement body. Interestingly, what this case illustrates is the difficulty that small developing countries can actually experience in utilizing the remedies that are available under the WTO's dispute settlement mechanism for securing compliance. In this particular case, Antigua and Barbuda received authorization to suspend its obligations towards the United States under the Agreement on Trade-Related Aspects of Intellectual Property Rights. It has maintained that if an amicable solution is not reached with the United States on compensation, that it may very well use its right to suspend its obligations under the TRIPS agreement. CARICOM countries have importantly also utilized the WTO dispute settlement mechanism as third parties. In several cases, CARICOM countries have utilized the mechanism to safeguard their trade interests in disputes which were initiated against the European Union to challenge certain aspects of their arrangements for sugar and their arrangements for bananas. CARICOM countries, as CARICOM banana producing countries or sugar producing countries, as part of the third parties of the African, Caribbean, and Pacific countries, also participated in these disputes in order to safeguard their preferential access to the EU market. And in that way, they actually sought to represent their interests in continued preferential access to the EU market through participation as third parties. But very importantly, there have been cases in which CARICOM countries have participated as third parties in order to register interests of a more systemic nature in the multilateral trading system. In 2 disputes, several CARICOM countries participated in order to register the importance to them as small developing countries of the rule of international law being upheld. And so the experience of CARICOM countries to date shows that as developing countries, as small developing countries, they have an equal interest in the dispute settlement mechanism of the WTO. They have an interest in participating not only to safeguard their direct trade interests, but also to safeguard interests of a more systemic nature. They have also actively used the dispute settlement mechanism, at least in one case to date, to seek implementation of the obligations and commitments of trading partners. And our experience to date shows that there is a continued interest that we should have in the reform of the dispute settlement mechanism of the WTO in ways that would ensure the fullest participation of all members in the system.